So today we're going to talk a little bit about planning for benefits and specifically planning around special needs. If you have special needs children, or if you have maybe loved ones that would benefit from qualifying for Social Security benefits or long-term care benefits and that sort of thing. And it requires special kind of planning to make sure that you're not affecting those benefits when you put things in place, because there's limits on the assets and the income and everything that somebody who's receiving government benefits can actually receive. And so the planning can get complicated very quickly if you're not careful, and you want to work with competent legal counsel to kind of guide you on what's specifically needed. In the special needs community, there's just one of the things that comes up frequently is we work with families that have children with autism. And so, of course, they call it a spectrum disorder, right? And so that's one of the things that we notice in the special needs community is that there's a whole spectrum of needs. And sometimes, there's a very extensive needs, and sometimes they're very basic needs. But at whatever level, it's important for you to have a proper plan in place, because emergencies will arise at some point where they need to be addressed. It's inevitable. And if you don't have a proper plan, then that's when things start getting out of hand, and stress and everything else that you have to deal with at that time. So let me start by sharing a story. We had a client of ours, and she had a daughter that had special needs, adaptive needs, and ever since she was born with fetal alcohol syndrome, and throughout her life she had trouble being able to be completely independent. So now she's 19 years old, and she gets on a bus, and I don't know how often she would get on a bus on her own, but this particular day she got on a bus, and she ended up going somewhere. She got lost, and the police end up picking her up, and she's at the police station. Well, she tells the police, I don't want to get in trouble. Don't tell my mom where I am. So her mom gets home, doesn't find her there, goes crazy, starts calling everybody, right? Eventually calls the police department. The police department tells her, well, your daughter's here, but we can't tell you anything. And because the daughter was 18 years old, she's an adult in the eyes of the law. She has all the legal rights and responsibilities and everything else that an adult has, even though she may not have the mental capacity to exercise those rights, right? And she requested that no information be shared with her mom. So her mom didn't, they couldn't tell her anything. And of course, that was stressful as well, right? And just imagine, the scenario could be much worse. Luckily, the situation turned out okay. But those are some of the things that we deal with when your child turns 18 and they can't be 100% independent. It's important to put things in place beforehand, because when you get to the emergency scenario, there's no quick options to be able to step in and fix things. Pretty much everything requires having to go through the court system if you don't have a proactive plan in place beforehand. And so what we're going to talk about are some of the basic needs and planning considerations that a family that has special needs individuals would want to consider, right? And let me pull up this slideshow here. So the first thing that we want to jump into is, why is it important for families, especially if you have minor children that have a qualifying disability, why is it important for you to have a different kind of plan? Why are there different considerations? And the biggest reason is because when you're receiving benefits, those benefits have strings attached. So in order to continue receiving those benefits, you have to comply with the guidelines for which you receive those benefits, right? And so there's different benefits programs in the US that people can qualify for. And by the way, if you have a child that's applied for benefits and they've been rejected, that's a common thing as well, right? We've actually heard that sometimes it takes multiple attempts, generally more than 3 attempts, to be able to actually get approved on benefits. So if you've applied and you haven't been approved, don't get too discouraged. Just apply again, right? Um, but when we talk about benefits, some of the things that are important to consider is that every program works a little bit differently. So we've put the 4 major benefit programs on a grid here, so you can kind of see the differences between them. And the first ones are related to money that gets paid out to the individual with a qualifying disability. And then the second ones are related to medical care or Medicare medical coverage that can be offered to an individual with a qualifying disability, right? And so when it comes to cash assistance, there's the SSI program and then there's the SSDI program. So what's the difference? Well, when your child is under 18, they're going to qualify for the SSI program, but they're going to qualify based on your income and your assets as a parent. And then if they qualify, then they're also going to qualify for the Medicaid program. The Medicaid program is what covers their healthcare and health insurance type of needs, right? And so Medicaid kicks in when you are able to qualify for the SSI program. And it's possible that you could qualify for one, but not the other. But it's most common that if you have a child with a qualifying disability, they're going to qualify for both. This is what's called a needs-based benefit. And so what that means is that you're limited on what assets you can own in order to continue receiving that benefit. And we just had a conversation with somebody just yesterday where they were asking, can I save up money in an account if I have a child that's receiving Medicaid and SSI? And the answer is you can only save up to about $2,000 of value, because if you cross that line, then it's going to start affecting your eligibility. And they do regular audits to confirm that you are falling within the guidelines for these need-based benefits programs. Once your child turns 18, then it's a different program that kicks in. If they qualify for the SSDI program, then the SSDI program would provide the cash assistance to them, and the accompanying medical coverage would be through the Medicare program. Once they turn 18, then your assets as a parent don't count anymore. They don't consider those anymore. And so the individual has to qualify on their own, right? Based on their own assets, their own income, their own situation. And so that's the difference between these programs. And most commonly, somebody who would be on this program is automatically then going to get approved for the next program. And that's why it's valuable to be on the SSI or Medicaid program, because when you then transition out, they're going to smoothly, very easily put you into the new program. And if not, then again, you have the problems with applying and whether they accept you or not, and how many times you have to apply, and blah, 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 right? And so that's a little bit about some of the basics on these benefits programs. And then the thing to remember is when you're actually working on, planning for these sort of situations, we don't want to leave anything that could disqualify one of your loved ones from receiving their benefits. So we want to maximize what they receive in their inheritance, along with whatever benefits that they would be able to receive, because the chances are that they're going to need that for the rest of their life, right? And so, whether they're high functioning or whether they're lower functioning, for the rest of their life, if they need support, this is the money that's supposed to be there for them and to support them. So one of the common pitfalls that we see in special needs planning is that a family will say, okay, well, Johnny can't receive any money, because if he receives money, he's going to lose his benefits. So let's disinherit Johnny. That's not the right answer, because if you disinherit Johnny, then what happens if he needs support later, right? And a lot of times families will say, well, no problem. We'll give all the money to his sister and she'll take care of him. But as soon as there's money on the line, and a lot of times, there's big responsibilities that go along with taking care of a sibling or taking care of somebody who has ongoing needs, sometimes that just doesn't pan out properly, right? So my first introduction to the special needs planning space was actually through my grandparents. They had a close family friend, and this family friend had a daughter who basically for her entire life had developmental disabilities. She would never be able to take care of herself or live independently or be able to find handle her own finances or anything like that. As it turned out, this daughter had, three step siblings, right? So there's three siblings that could take care of her. But the intention was her mom, who was a widow, had left her instructions that she wanted my grandparents to step in and be the guardian and to be able to take care of her if something happened to them. Well, she never got around to doing a proper estate plan and doing a trust or doing a will or anything like that to nominate them. And because there was nothing in writing when she passed away, then my grandparents didn't have anything that they could actually rely on to be able to get over her or to be able to assist. And so because of that, when it came time to actually decide what was going to happen with her, she inherited all of mom's property, right? The siblings showed up and they said, hey, we don't want to take care of her, but we want the stuff. So they took all the stuff from the home. They said, hey, she can't have this money, so we should spend it all. So within a few months, they spent all the money. And then they said, hey, we don't want to take care of her, so let's put her in a group home. And then they put her in a group home, right? And my grandparents spent 12 years trying to become the guardians over her, with the state of California fighting them tooth and nail the whole time. And so if you want to have a say as a parent in who's going to take care of your child, or if you want to have a say in how they're going to be treated, how they're going to be taken care of, how the assets are used for their benefits, those are things that need to be put into an actual plan, put in writing, because otherwise the chances are that it's not going to be followed. And you're relying on people's good graces to actually do what's right. But when there's money on the line, sometimes people change, right? And so if what's, if it's important for you to make sure that you leave a share for each of your children, make sure they're taken care of, it should be even more important for somebody who might need assistance later in life to actually leave more for them. Instead of disinheriting them, it would actually be better to leave a pool of money specifically for their care and benefit when you're gone, because it's going to be hard enough for them, right? All my kids are under 8. The oldest one just turned 8, right? They're not old enough to explain to somebody how they should be raised. They're not old enough to explain to somebody what time curfew is, right? What kind of movies I want them to watch, what kind of religion I want them raised in. All those things that as a parent I would know. If I don't put it in writing, they're not going to be able to explain to somebody what all those things are. And even with the best intentions, somebody else stepping into that role wouldn't be able to actually provide the guidance or the support that would be necessary for them, right? So as a parent, if I want to have a say, those are things that it's important for me to put into written form in my estate plan. And the other thing to remember is that with a child that has adaptive needs, special needs, it's very important to make sure that there's consistency in their life. And if they have special treatment or special medication or special support that they need, that's also important to leave instructions for. One of our clients has a son, and he was turning 18 at the time when we were sitting down with her. He had just turned 17, but he has several conditions, and one of them is actually where he has epileptic seizures, right? And he has a special machine that helps him while he's having seizures. And you have to receive training on how to use that machine, because if you use it wrong, you could actually kill him, right? And so any place that he goes to that she has to leave him for them to care for him or for them to be able to support him, they have to have somebody on site trained in how to use his machine. And she makes sure of that, right? But if she were gone, that's one of the things that she wanted to make very clear in her planning, that this machine exists and whoever's his caregiver needs to know how to use it, right? And if they leave him somewhere, they need to make sure they leave his machine with him, and that whatever facility or group home he ends up being in, that they have somebody on staff that knows how to use it. Those are very clear, specific instructions that if it gets overlooked, I mean, who would know, right? and a caregiver providing support and whatever, how would they know what to do if they didn't have those instructions? So these are important things to consider as part of your planning process. The other thing that's very important to understand is that when you're planning, you need to consider, who the other parties that may be taking an interest in the situation are going to be, right? And so, when we look at benefits specifically, again, this is what we were talking about earlier, right? If you're eligible for SSI, then there's a two-part test. Part of it is determined by your resources, and part of it is determined by your income. And if you meet both of the tests, it's based on the parents while your child is under 18, right? Then you receive the benefits. If your child would then receive an inheritance because you happen to pass away, or you and your spouse pass away, then it's possible that they could lose their benefits and have to reapply. And of course, like we talked about, they might not get approved the first time. They have to apply over and over again. It might take 6 months, a year, however long for them to get back on benefits. That's the risk, right? And so, we have to consider the parties that are going to be involved here. Who's going to be responsible for that process? Who's going to be responsible for making those decisions? It's probably going to be a family member, maybe a trusted friend, right? But when you have a special needs child, the state automatically takes an interest. And so, the default under state law, if you haven't designated a guardian for your child, for, no matter what age your child is, if they're underage, the law says that any interested party can nominate themselves to be the guardian for your children. When you have a special needs child, the state considers themselves an interested party. In fact, they may consider themselves the most interested party, right? And so if you haven't designated who you want as the guardian, then the state is going to step in. And then what happens then? Well, they go to the foster care system. And that may be temporary while somebody is appointed, or it may be permanent, right? But either way, the state has an agenda for how they're going to make decisions and how they're going to take care of your child's needs. And it may not match what you want for your child, because the path that the state takes of making sure that they're cutting costs and so on and so forth. I'll give you another example. We have a client of ours that we were assisting with some advocacy because he has an adult child with special needs, and his son receives benefits and is part of a group home sort of situation. And because of circumstances, he doesn't live with his dad anymore. They butt heads every once in a while. But the dad cares about him, and he's involved in his life, and he's around regularly, and he wants to have a say. So we show up for a meeting with the managers of the group home and the coordinators for his benefits, and with his dad, and it's in front of an administrative judge, right? And we're having a discussion. And to put it, just in easy terms, there was him and there was me, and around the table there was 15 other people that all represented the state. And if I wouldn't have been there, it would have just been him, right? And so dad is trying to explain what he's concerned about for his son's care. He's trying to explain why he feels that things should be done a little bit differently for his son's care. And he's getting shouted down by 15 other people in the room. And because we're there as legal counsel, we're providing him with the support to be able to, get control of the room and be able to take care of having a civilized conversation. But just imagine when you have one of your children in the state's, hands, where they're taking care of all the decisions for them, what are the chances that they're going to make the decisions in their best interest? I know that that's what they're there for, but what are the chances that without having an advocate on their side, that they're going to make the decisions for their best interest? And so for this type of planning, another thing to consider that's very important is we need to make sure that we have checks and balances. You never want to put somebody in a situation where there's potential risk or liability, or they're having an issue with managing things because nobody's looking over their shoulder, right? If there's the temptation for them to improperly use assets or to manage things improperly, then that could cause problems. So the most common way that we address some of these concerns is by using a special needs trust. And we'll talk through some of the benefits of that, but we can build in checks and balances into that trust plan structure to make sure that we're addressing things properly. So what are the benefits? Well, some of the benefits are, number one, it preserves your eligibility for government benefits, the SSI program, SSDI programs, Medicaid, and so on and so forth. Number two, because they're still receiving their benefits and the money that they would inherit, whether it's from life insurance or whether it's from other assets, it's also going to be there to take care of them. That's going to mean that they get a better quality of life, right? Because not only do they have their basics covered, they also have money that can be used to, at the trustee's discretion for their benefit. The third thing it does is it provides a framework for the care and the management of those assets and to be able to take care of your child or your children. And so it's going to say specifically what you want things to be used for and how they should be managed and so on. And it's also going to allow for somebody to be able to step into your shoes without having to go through the court system to do that. So as a parent, again, we talked about this earlier, there may be things that you want to express, that you want followed, or that you want to be able to provide guidance on, that if you don't put it in writing, it could very easily be overlooked or forgotten about, right? And so those are things that we want to build into your plan and specifically point out as part of your planning. But the other thing that happens sometimes, and we've seen this time and time again, whether it's with minor children or maybe adult parents that are losing capacity, there are companies out there that specifically target vulnerable people to be able to take their money or their assets. They convince them to buy things that they don't need, or they convince them that they need to spend money on services that they're never going to receive. And there are companies that specifically market to vulnerable individuals for that purpose. When you go through a public process like a probate or a guardianship, those files become a matter of public record. And then that information can be found and sold to companies who are trying to target vulnerable people, right? And so, one of the things that helps is if they don't have direct control over their own assets, then they can't be convinced to use them improperly. Does that make sense? So the Special Needs Trust provides a framework to be able to protect those assets so that they can't be misspent, misused, and so on. And as a result, it extends the life of those assets. And one of the things that we see all the time is that the average inheritance, regardless of the situation, right? Whether it's $100,000 or $100 million, on average, it's going to be spent in less than 7 months. So, again, my children are all young. They have a whole life ahead of them. If I died tomorrow, I would want my life insurance and my business interests and everything that I leave for them. I want them to last for their entire life. If it's spent in less than 7 months, I mean, is it going to do what it was intended for? No, right? And so you want to have a plan in place to make sure that it's going to be used appropriately and it's going to be actually, serve the purpose that it was there for. So some of the details of these plans are, number one, the actual individual with special needs or adaptive needs, if they need support in making decisions and so on and so forth, we don't want them to have direct control of the trust assets. So we put a trustee in place to be able to take on that role, that responsibility, right? And the trustee is then responsible for managing the assets for the individual's benefit, for your child's benefit. And then those assets are exempt for them to be able to qualify for their benefits because it's not owned by them. Does that make sense? And so there are types of trusts where it's specifically available to a child and they can demand, a payment or they can withdraw things at any time that, might be known as like a support trust, for example. That's not how this works. The Special Needs Trust doesn't give them access because if they did have access, then the state could force them to withdraw the funds. We don't want that to happen. So it can either be completely at the trustee's discretion, or it can be according to the guidelines that we set forth in the document. But either way, once the trust is there, it's there and it doesn't change, right? And if you pass away, it becomes irrevocable, so it can't be changed at that point. Or if we set up a standalone Special Needs Trust, then again, it would be irrevocable for the purpose of protecting those assets. And then we can build in checks and balances to that process. So we can have somebody looking over the trustee's shoulder if we need to, called a trust protector, and they can step in to fix things if the trustee is doing something wrong. Or we could have a different individual who might be responsible for making the day-to-day decisions for your loved ones, called the guardian, right? The guardian might be a different person from the trustee, because the trustee's good with money, handling the finances, making sure that they're taken care of from the financial perspective, but the guardian is responsible for the day-to-day living decisions and so on and so forth, and so they can work together. And like they say, it takes a village to raise a child. But it's the same philosophy when you have somebody who needs support on day-to-day living, right? It's important to have multiple people who are taking an interest in their life. So let me share another story. There's a good story, a success story. We had a client of ours, and she had cancer. She knew she was going to pass away. She had an adult daughter who lived with a roommate who assisted her with a lot of things, but she really wasn't in a situation where she could take care of herself completely, and she wouldn't be able to take care of her finances on her own. And so we put a plan in place to make sure that there was a special needs trust to be able to leave everything on for her daughter's benefit. And we had, first of all, when we did the plan, there were several friends who were close friends of the daughter who wanted to be involved, who wanted to take an interest in support, right? But the person that we named as a trustee actually didn't live close by, and we named somebody else who could assist as the personal representative for the estate, because there were some assets that we couldn't put into the trust. And then there was the roommate, right? So when mom passed away, I got 5 calls within 2 days from different people, just wanting to make sure that she was okay, that her plan was working, that her finances would be handled properly. When we sat down to look at things and to make some decisions on the financial side, we had a room of 8 people that were all working together, collaborating to make decisions on her behalf, all advocates for her, right? That's what you want. When you're gone, you want to have a room
I
full of
thought it
people who
was a CDLS.
and so that's exactly what we're looking to accomplish in the planning, is to make sure that we have a room full of people who care when you're gone as a parent. So your complete special needs plan would include a special needs trust, right? And whether that's built into your regular family trust plan, or whether it's a separate, standalone trust. There are also different options depending on the situation to be able to structure, a pooled trust or other solutions like that. That if you're interested in those sort of solutions, we can certainly sit down and have a consultation. And because you came as a referral to this presentation, there's no cost for that consultation. But your plan would also include the important documents that virtually everybody needs to have for their estate planning anyway, right? Powers of attorney over financial affairs, healthcare directives or medical powers of attorney, right? You would have a will, which puts anything that's not in the trust or into your trust plan, it would put it into the trust plan just in case, right? And that's where you're also going to designate the guardian for your children. And remember that if you have, minor children that are under 18, those children you need to name a guardian for them. But if you have adult children and they have special needs and they have ongoing needs, you may also need to designate a guardian for them. And if you have a guardianship or a conservatorship over your children, you can designate who your successor would be. You might need that to get approved by the court, but it's important to make sure that you consider that as part of your planning. And then another part of the plan could be what we call a care plan, which is all those instructions that we talked about earlier that you would want to leave, the guidelines that you would want to leave as a parent. That's where you put that, is in that care plan, to provide guidance and instructions overall for how things should be managed and what decisions should be made, right? And then another very important consideration we just talked about is when your child turns 18, your authority as a parent ends, because now they're an adult, and the eyes of the law doesn't see what kind of needs they have or what kind of disabilities they have or whether they're competent or not competent. The eyes of the law doesn't see any of that. And so if they need assistance on an ongoing basis, then you're going to need to make sure that you either acquire guardianship over them or that you designate for somebody to be able to do that, right? And so the easiest time to do that is when your child first turns 18, when they become an adult. That's the best time, the easiest time to actually step in and be able to get the guardianship, your because the court recognizes at that point the importance of the process, and they make it, a lot easier in most states, and make it a lot easier to be able to acquire guardianship at that point. And so again, guardianship is over the decisions over the person, over their living conditions, over all that sort of stuff. And then conservatorship, or the equivalent of it, some states call it guardianship over the estate, is over all their finances and accounts and assets. And you may need one, you may need both. It doesn't have to be a complete guardianship or complete conservatorship. It may also be limited, right? And so it's important to consider, based on your child's needs and abilities, which of those options is actually necessary. But in addition to having your plan, you also need to make sure that it gets funded correctly. So funding means transferring title to assets and making sure that everything is left properly as part of the plan. But it's important to consider, what are you leaving behind? And if you want to leave specific assets, specific amounts, or specific, value for your children, you may want to consider having a life insurance policy specifically for that purpose. So maybe you have 5 children, but one of them is going to have ongoing needs for the rest of their life. You may want a life insurance death benefit to leave specifically for their share, right? Because they're going to have ongoing needs that need to be paid for. So sometimes people say, well, but that's not fair. We're leaving more to Johnny. But sometimes life isn't fair, right? It doesn't have to be equal in order for it to be fair. Fair can mean different things to different families, right? And so we want to make sure that you're leaving behind what's important to accomplish your purposes. And if that means having a specific life insurance to be able to properly fund a special needs trust, that could be a very good option. And in fact, there's survivorship policies that will pay out not when you die, but after both you and your spouse die. Then it pays out, and that keeps the cost a lot lower on the policy. So that's something to consider. It may also be something to consider, look at, annuity options, which can provide income instead of providing an asset. Because if the asset would disqualify them from benefits, we can instead turn it into an income stream to be able to accomplish those purposes. So those are some of the considerations. And we have attorneys within the firm that this is basically what they focus on. This is what they specialize in, is planning for special needs and working with special needs families. And so if you're interested in sitting down, having a consultation about your specific needs, we'd be happy to schedule that. And because you were invited again, that would be complimentary. And then we would let you know what the costs would be if we actually do implement a plan